Well, wonderful. Welcome, everyone, to the International Forum on the Future of Constitutionalism for a seminar on clerking at the Supreme Court of Canada, Perspectives from Former Clerks. My name is Richard Albert. I'm a constitutional law professor and director of the International Forum, whose mission is to marshal knowledge and experience to build a world of opportunity, of liberty and dignity for all. This seminar is intended for all who are interested in clerking. Part of my objective here is to demystify the process, to make it accessible to all, and also, most importantly for me personally, to encourage students from underrepresented groups to apply and thrive. So I've assembled a wonderful group of former clerks, my first round picks actually, the very first people I invited, to share their advice and experience about clerking with you, not only at the Supreme Court of Canada, but at trial and intermediate courts too. Annamaria Enenajor, partner at Ruby Schiller Enenajor Di Giuseppe, clerk for now Chief Justice, then Justice Richard Wagner in 2012-2013. Kyle Kirkup, Assistant Professor of Law at the University of Ottawa, my hometown, clerk for Justice Louise Charron in 2010-2011. Malcolm Lavoie, Assistant Professor of Law at the University of Alberta, clerk for Justice Rosalie Abella in 2013-2014. And Jodi Lazare, Assistant Professor of Law at Dalhousie University, clerk for Justice Michael Moldaver 2012-2013. I clerked for Chief Justice Beverley McLachlin many years ago in 2003, 2004. And while in law school, I interned at both trial and intermediate courts too. We'll begin with remarks from each of the speakers on a different part of the clerkship experience. And the rest of the time will be reserved for questions from you. We'll go for about an hour, ending at just around 2 p.m. Ottawa time. When the time comes, if you'd like to ask a question, please send me a message in the private chat function on Zoom. I'll try to group the questions by theme and to sequence them in a way that I think is productive. Please also tell me how you'd like to be introduced so that I can recognize you appropriately. So that's our plan. Let's begin. Kyle, what is the application process like?
So the application process has changed quite a bit over the past few years. So I went through the process in 2008, which feels like ages ago. So I submitted a cover letter, a CV, my transcript, 3 academic reference letters, and a writing sample. And because I was at a Canadian law school, I submitted those materials to my dean, because the deans of Canadian law schools are tasked with writing kind of synthesis reference letters on the candidates that they've decided to put forward for consideration at the Supreme Court of Canada. So his team reviewed the materials. They invited me and other selected candidates to, for an interview with the dean. He got a sense of who I was able to write a reference letter on my behalf, and then the whole package went into the Supreme Court in January. And then I waited with much agony for about a month or so. And then all of a sudden in February, in pops an email into my inbox from one of the administrative staff at the court indicating that I had been selected by some judges individually for interviews. So during this process, you're basically invited to Ottawa. If you're in Ottawa, you just walk down the street. And I went in March for a series of interviews with individual judges who had selected me based on my materials. And we had a 20 to 30 minute conversation. And the interviews really varied depending on the judge. Some were quite formal, like I could tell that they were formal because we would sit at their desk. We would talk about substantive law. They would ask me about cases I disagreed with. It was quite formal. And then other judges were far more informal, more casual, and you could kind of get that cue from when they asked you to sit at their couch and talk about more personal things. So when I interviewed with Justice Charron, we ended up speaking about growing up in small towns, myself in Manitoba, herself in Northern Ontario. We talked about having both studied at Carleton and the University of Ottawa. And I left that interview being like, that was either the best interview I had, or I didn't talk enough about substantive law. Maybe she doesn't want to hire me. And then about a day or two later, I was in class, and I never do this, but I did on that day. I had my cell phone on, and the phone went off with a number that I recognized as a Government of Canada 993 number. So quickly stepped out, and there she was on the line to offer me the position a couple days after the interview. So that was the process in 2008. What's important to know is that in the years that have followed, the process has shifted a little bit. There have been a couple of judges that have come onto the court who have brought some innovations, one of which is a panel process, which individual judges can elect to participate in. So this is more of almost like a government style panel interview. So judges that elect to select out of the pool basically are involved in reviewing files. Two judges and then some staff lawyers from the Supreme Court are responsible for conducting the interviews for the pool, and then judges that have elected into the pool then select candidates out of that pool. Now this is interesting, it's become a bit of a bifurcated process. So there are the judges who have opted into the pool, and then there are other judges who have opted to maintain the one-on-one, more personalized interviews. And we've seen that shift over time. Each year, the numbers shift a little bit. And so this was a pilot. It seems to have, worked in some ways, and some judges are using it, and other judges have decided that they prefer the one-on-one experience to get a better sense of the candidates that they're going to be working with very closely for the year. And then a final innovation that happened this past year, and this was in the pre-COVID times. Typically, you would expect if you had an interview, you would be invited to come to Ottawa. The court would pay for your travel expenses, your hotel and your flight or your train. But this year, the court piloted doing all of the interviews online through Skype or another webinar feature. So that happened this year. And I get the sense that, moving forward, this is certainly going to be the practice of the court, at least for the next year. And at the end of the day, what happens is once all the interviews are completed, the Supreme Court of Canada justices start to make their picks. And it's typically described as being a bit of a hockey pool. So the most senior justice, the Chief Justice, will typically pick their clerks first. And then they will move through the chain from the next most senior judge down to the most junior judge, then back up the chain a couple of times. And once each judge has 4 clerks for their individual chamber, then you have a total of 36 clerks at the court, and the candidates have been selected for 2 years in advance. So this process starts quite early for 2 years in advance. So that's kind of a thumbnail sketch of how the application process works and a little bit about how the selection process works.
That's great, Kyle. One question, it seems to me the dean is very important in this role. Does that mean that interested applicants should go and get to know the dean ASAP and try to impress her? By taking her classes, by offering to be a research assistant. It seems to open itself up to some gaming.
So at our school, I don't know, I can speak, Ottawa U is a fairly large school. So the dean doesn't typically teach very many courses. So, and I think at least in part, because of that, we have a very formalized process. So we have a clerkship candidate committee where former Supreme Court clerks who are now professors and a couple of administrative staff from career services review all of the applications. We read them very carefully. And then what we do is we invite all of the selected candidates in for an interview with the dean and with the members of our internal committee. And we see how they perform in an interview situation. And we get to know them better. And then the dean, based on that decision, then makes a series of decisions about who he's going to put forward and give the reference letter to, and then he goes about writing the letter. So I'm sure at different schools, these dynamics play out in different ways, but at our school, the way we've tried to make sure that the process is fair and there's an even playing field is that all candidates submit to a committee.
That seems like the right way to do it, to convene a committee to help assist the dean in the decision-making. Well, thank you very much, Kyle. Annamaria, so you get the clerkship. What do you do, if anything, in particular, to prepare for your clerkship year before you get to the court?
So I actually wanted, before jumping into that question, to to talk a little bit about an issue that's a follow-up to what Kyle just discussed, which was you finish your application process and you get an interview, and how do you prepare for the interview? I thought that might be helpful to talk about, only because the way that I prepared for the interview kind of mirrors the way that I prepared for the clerkship itself. So the way that I prepared for the interview, or one of the ways that I prepared, was to understand the work of the court. And to immediately try to ask myself the question, how do I add value to that work even before I get there? So I used the interview process as a way of trying to convey what value I would bring to the court. And one trick, or not, it's not really a trick, but I think if you don't really sit down and think about this, you may not be able to game it out in your head. But you can actually determine with a small degree of confidence what certain judges are working on at a particular time, because you know when certain hearings have taken place, you know the disposition of certain judges when it comes to certain issues, and so you can kind of guess with a reasonable degree of accuracy what judges are thinking about that week that you are going to be interviewing with them. So for example, if I know that 3 weeks before there was a decision, 3 weeks before my interview at the court, there was a decision from the Ontario Court of Appeal that came up, and it was about bail. I know that Justice Wagner has made it a point to speak on bail issues in a number of the number of recent bail cases. There's Antics, or a number of cases that are really important on the question of bails. He's drafted the opinion. So I'm, with a reasonable degree of certainty, I can guess that if there's a bail decision that has been heard by the court 3 weeks before, it's very likely that he is going to be thinking about it. It's going to be top of his mind. So when I go and speak to him about what my interests are, if I happen to be, as I am now, a criminalist and really interested in criminal law, I want to talk about that bail decision that he just heard 3 weeks ago. If it's a decision on challenging the new legislation on sexual assault, a number of those are coming up. The Court of Appeal, the Supreme Court just granted leave in JJ, which is a Court of Appeal decision that's about challenging Section 278.92 of the Criminal Code. Those 278 sections and subsections, those are all brought in Bill C-51, is omnibus legislation on dealing with sexual assault offenses, and they have been systematically challenged by in a series of criminal defense cases. I know that if that decision comes before the court, Justice Kirkup is probably going to have something to say about it, because she had something to say about in Goldfinch, and she had something to say in Gladue, and so those are the decisions. So I know that it's going to be on top of her mind if I'm going to be interviewing with her, and she knows that decision has just been granted leave. So what I try and do, or what I tried to do, was I tried to identify the areas that my judges are interested in, what cases have come up, cases have been recently granted leave, and think about things that they are thinking about as they're going through deciding on these questions, these important questions. And I did that both in preparation for my interview and also when I got to the court. So before arriving at the court, I knew that my justice, I was selected by Justice Marie Deschamps, and later ended up clerking for Justice Wagner. But for the first 2 months that I was at the court, Justice Deschamps was my judge, and I knew that she was one of the 3 Quebec judges. And there was an important case about the interpretation of Quebec bankruptcy law when I got there. So I knew that is what I should be preparing for, and that is the area of law that hit the ground running. I need to know something about, and I need to be able to understand at least the basics of. So I educated myself about that. It's easy to do if you know, if you can try and get a sense of what the judge that you're going to be speaking to, either at the interview or whether you're or clerking for, what their area of interest is, if they're one of the 3 Quebec judges, what was just granted leave to appeal. In cases that are sort of cases of national importance that have been brought before the court, that are attracting many interveners, that are attracting media attention, have a look at those webcasts online and see what kind of questions your judge was asking to the parties that were before the court. So all of those are just little tips that really make you an engaging person to have a conversation with and add value to the work of the court.
Those are great tips, Annamaria. Is it appropriate to ask the judge for whom you'll be clerking if there's anything you should be reading before you get to Ottawa to start the clerkship?
That's a really good question. I think that judges would be reluctant to speak about the work that they are doing prior to you getting there. I think that judges would say, you know, enjoy your summer and come with a fresh mind, ready to engage in the very important, very difficult questions that come before the court. So I don't think that you would get an answer that would be of much assistance from a judge. There are confidentiality issues once you get there. Judges aren't always comfortable speaking openly and publicly to people outside of the court about what they're working on for good reason. So I don't expect that you should get that answer from the judges, but I think, again, through the art of deduction and through just exercising, you know, your basic reasoning skills, you can work backwards from the resources that are available on the court's website, what you know about judges, and what you know is coming down the pipeline from various courts of appeal.
As any resourceful law student or recent graduate would know to do.
Exactly.
Thank you so much, Annamaria. So, Kyle, you've told us about how to apply, what the process is like. Annamaria has explained to us how to prepare for the interview and then how to prepare to actually start the clerkship. Now you get the clerkship and you start. Jodi, what's a typical day like, assuming there is such a thing?
Right. Well, first I want to thank you, Richard, for organizing this and for inviting me, and thanks to fellow former clerks as well, and to the registrants. Well, I mean, you implied that there isn't a clear answer to this, and my first sort of thing to say was going to be the usual lawyer joke, which is, you know, that it depends, right? It depends on whether the court is in session. It depends on whether you're working on a case that's coming up or being heard that day or the next day or was just heard, whether your judge is writing a decision, you know, and a number of other things. So it's really hard to describe a typical day. So what I'm going to do instead is talk a little bit about the process of working on a particular file. And in doing that, I'll touch on a number of things that a clerk might do in a typical day. And of course, I'm speaking in general terms because even as former clerks, we're bound by confidentiality. All right, so some of you may know that there are 3 sessions at the court during a 1-year clerkship, fall, winter, and spring. So one of the first things you'll do as a clerk when you arrive, or once the calendar for the next session is out, is decide amongst the individual clerks or amongst the 4 clerks, I guess now, for each individual judge, who will work on what cases. So you divvy up the cases that are upcoming, and you'll do that at the beginning of each session. And then the details of what work on a case or a file look like really vary from judge to judge. But the gist of it is this. A clerk working on a case will read all of the materials related to that case. So that includes lower court decisions, all of the facta or written arguments submitted by the parties, as well as any interveners. And then often you'll do some additional research, case law scholarship, you know, the usual stuff. And all of that is in preparation to write what's called a bench memo, which is a term some of you may have heard, for your judge. And that is essentially a memo that your judge will read in order to prepare for a hearing and familiarize themselves with the case. Different judges like different things, but a typical bench memo is going to include a summary of the facts in the lower court decisions, a legal analysis, often drawing on the parties' arguments and those additional authorities that I mentioned, and often a recommendation, your view of the case, you know, how it should go, which of course your judge is by no means bound to follow, but you know, it's fun if they do. So again, the details vary and the timing varies and deadlines vary according to your judge. All have different preferences. Sometimes a bench memo is all that a judge will want in preparation for hearings, but sometimes your judge might want more. So they might ask for a meeting to discuss the case, to discuss your recommendation. They might want further research on a specific question of law, which you'll go and do and then bring back to them, or on a question of fact. So that could mean going into the evidence, affidavits, transcripts, and you have access to all of that. So really your judge can ask you for anything related to a file. They might also ask you if there are specific questions they should be thinking about during the hearing or that they might want to ask from the bench. So essentially, you know, you're their wing person for the cases that you're working So that's the before. The juring is fairly straightforward. A clerk working on a particular case sits in for the hearing of that case. If you've ever visited the Supreme Court of Canada building in Ottawa, you'll have seen in the main courtroom to the right along the wall, if you're looking at the bench, is a long table, and that is where the clerks sit and observe a hearing. And during the hearing, you do sort of what you would expect, take notes on, maybe things that you've talked about with your judge or anything that you think is relevant to the case. What happens after a hearing, again, depends on the judge. Nothing I say here is not already out there. I'm actually going to refer to when Justice Binney retired from the court in 2011, he gave a very detailed exit interview to the Globe and Mail, and he talked about the process, what the judges do together after they hear a case and how a decision is made. So I'll touch on some of that. So after a hearing, the judges will hold what's called a case conference, where they get together and discuss, their thoughts on the case. After that, some judges will then meet with their clerk, some will not, some might share the details of the conference, others might not. Your judge might just tell you what they're thinking after the hearing. Your judge might say, I have volunteered to write the decision, or they might tell you nothing at all, right? So what happens after a hearing basically really depends on your judge and their role after the hearing. If your judge is writing reasons, you're typically going to work with them on those reasons, often providing further research, sometimes editing, proofreading, that kind of thing. If your judge is not writing, as the clerk assigned to a particular file, you'll receive a copy of anything that's circulated among all the judges on that file. So in that interview, Justice Binney discussed the fact that judges circulate sort of multiple drafts of reasons, often many multiple drafts before they're complete. So that's what I'm referring to here. It's your job as a clerk assigned to a particular case to read those drafts or memos and provide feedback to your judge. And here again, your judge might ask you for more work. They might ask you to research a particular point they're not sure about, maybe something they agree or disagree with in the reasons. And so it goes. Your judge might find that they fundamentally disagree with some of the reasoning. They may decide to write a concurrence or a dissent. And again, you would work with them on that. And basically that same process continues until all of the judges are satisfied, either with a set of reasons or a number of different reasons on a particular case, until it's done. So that's the gist of it. I'm probably running out of time. I just want to, if it's okay, just add a couple of things that are not kind of case related. You might do work, research for your judge that's not related to hearings. So as you all know, Supreme Court of Canada judges are in high demand. They give lots of talks at law schools, conferences, that kind of thing. So you might help your judge with that. And then there are the sort of non-professional or non-work aspects, which I could speak for another 7 minutes about, but I won't. So I'll just give you a short list. When I clerked, we had regular fireside chats. I think it was once a month, so one with each of the judges and some outside guests as well. So we heard from some former prime ministers, for example, and others. We were also guests of the Governor General at the time, guests at Rideau Hall. So there's a lot of opportunity to learn and take advantage of these other kind of more extracurricular activities that clerks are really kind of privileged to enjoy. There are birthday celebrations, 36 clerks now, so that must mean like a lot of cake really often. Holiday party, gift exchange, that kind of thing. And clerks have a hand in organizing all of that stuff. So clerking is, educational and professional, but also, of course, a social experience. I'm going to stop there for the purposes of time. But I'm very happy to answer questions.
That's wonderful, Jodi. Thanks so much. Let me ask you a question to follow up on the clerkship year. What is the intra-chambers dynamic like? When I clerked, we had 3 clerks per judge. Now I guess there's 4. What was it like? You mentioned one thing that you guys do, which is you divvy up the cases. Perhaps that's at the instruction of the judge. Perhaps you guys work it out among yourselves. Maybe say something about how you guys work together.
So I actually I'm curious how that works now, because there's 4. So when we had 3 judges per clerk, for example, divvying up the cases, that would be at our own initiative. I don't know that any of the judges imposed particular cases on particular clerks. I could be wrong. but it worked out nicely because there's 3 sessions and 3 clerks, so you would rotate sort of who picked first each time. Presumably the clerks now have figured out some kind of way to do that that's equitable. Interestingly, I mean, of course you develop a bond with your co-clerks, but you actually end up working a lot more with the other clerks for other judges who may be working on the same files as you. So there's kind of like different dynamics, and you don't actually work that much, you know, in substance with your co-clerks who work for the same judge. You're muted.
I was unmuting myself.
Okay.
Great, thank you very much. That in fact was one of the questions that I got in the chat queue, but it was also a question I had. So thank you for answering that.
Okay.
So we know how to apply. We interview, we get the clerkship. We start our clerkship when we have a typical day experience. Malcolm, do you have any big picture or maybe nitty gritty advice for people who are interested in applying to clerk?
Yeah, thanks. Thanks, Richard. Thanks for organizing this. I think it's going to be a great resource for law students, and thanks for the invitation to be here and speak. So yeah, I'm going to speak a little bit about advice for those interested in clerking, and so I'm assuming that you want to clerk, and so the advice is mostly geared towards how to make sure your application is successful. So the first thing I'll say is that grades are important. There's no way around that. They're important, but they're not everything. So my first piece of advice would be to take the academic side of law school seriously, but at the same time to keep things in perspective, right? So one bad grade is not going to ruin your chances of clerking, and you don't have to be a gold medalist to get a clerkship. I didn't graduate with a medal. How could I when I was in the same class as Annamaria? She of course did get a medal, so clearly it doesn't hurt, but it isn't the be-all and end-all when it comes to getting a clerkship. So first piece of advice is pay attention to your grades. The second piece would be to think a little bit about your reference letters. So if you're applying to the Supreme Court of Canada, there will be 3 reference letters that you're responsible for, plus the dean's letter. Now, the dean's letter is typically from an institutional perspective. You don't necessarily have to know your dean, but the 3 other letters are under your control. Ideally, these will be from people who know you reasonably well and who will unhesitatingly endorse your application. You wouldn't want lukewarm letters. Ideally, I think these letters would come from law professors. They would tend to be given more weight than, say, a letter from a lawyer that you worked with. Not that I think the reason for that is just that law professors see more students, and there might be a perception that a lawyer that you've worked for is just sort of automatically going to endorse people from their firm. So 3 letters from law professors ideally. A letter from a judge might also be a reasonable option if you've already clerked by the time you're applying. So that might be the one caveat to that. How you might go about getting these references. You ideally want someone who can speak to the relevant skills that a law clerk will need. And so those skills would include legal analysis, legal writing, legal research. So some ways that you might get a good reference letter from a law professor would include, doing well in a class, particularly a smaller class where the professor might remember you and remember your writing skills or your ability to think through legal problems. Working as a research assistant is another common way to get a good reference letter, and there the skills really are quite relevant, right? Some of the work you might be doing for a law professor as a research assistant could be quite similar to the work that you would do as a law clerk in terms of providing research memoranda, that kind of thing. Another way that you might get a good reference letter would be to write a supervised independent research paper. There you'll work with a prof who will be familiar with your writing, your ability to provide analysis of novel and interesting legal questions. So that's not exhaustive, but those are ways that you can go about having three law professors who know your work in a relevant sense and who can endorse your application. Beyond that, I think there are a few things you can do to increase your odds. I wouldn't want to say that any of these things is a strict requirement, but if you're thinking about applying, there are a few things you could do to up your chances. So when you're talking about the Supreme Court of Canada, one of the things that is increasingly important is not required, but increasingly important, is if you already have a lower court clerkship. So it's increasingly common for clerks to come to the Supreme Court of Canada having already done a clerkship at a lower court. So that would be the typical sequence would be a court, often a court of appeal the year after you graduate law school, and then the Supreme Court of Canada after that. Like I said, it's not a requirement, but it's a plus. It is, of course, relevant experience. It's probably true that a court of appeal clerkship might help you more, although that may depend on the judge. And certainly, I think any clerkship that you would already have would be a plus. And of course, you're applying for these things a year and a half in advance. So if you got one for the year after you graduated from law school, you'd be applying for the Supreme Court of Canada, not having done that clerkship yet, but you could say, I'm going to be clerking at, say, the Ontario Court of Appeal next year, and that would be something that would help your application. There are a few other things you can do. Academic publications. Most applicants for clerkships do not have academic publications, but they are definitely a big plus. As a law student, it might seem far-fetched that you might be able to do this, but it is very much possible, and a good way to do it would be to write, say, an independent research paper for a prof, and then talk to that person, talk to that instructor about publication options if they think there might be a way to publish it. Most Canadian law journals, I think, will consider papers from students, and there are some that exclusively publish papers from law students. So I think the University of Toronto Faculty of Law Review is one of them. Appeal at UVic may be another. So like I said, most applicants don't have that, but if you do, it's a plus, because again, it goes to those relevant skills. It goes to your ability to think through a legal problem, express yourself clearly on a difficult legal question. Writing prizes help. So if you do write something, think about submitting it for a writing prize in your faculty of law. Law review experience, also a plus, not a requirement. It's a plus not necessarily because it's super competitive to get on a law review in Canada. Often it isn't. It's a plus instead because of the skills that you need and that you develop as a law review editor. Attention to detail, text editing skills, the ability to sort of understand how a legal analysis should be presented. Those are the sorts of things that you would presumably acquire as a law review editor. The last point I'll speak about is bilingualism. So it's some people sometimes are under the misapprehension that you must be bilingual to clerk at the Supreme Court of Canada. That is not the case. It is a plus, but not a requirement. Unilingual law clerks are selected every year. In terms of where your language skills need to be in order for it to be something that'll help you, I would say you don't have to be sort of perfectly at ease in both languages, completely fluent. If you are able to understand written and oral legal arguments in French, that is enough to be useful to a judge, and it is something that you should note in your application. I would say be honest about your French skills. Do not exaggerate your French skills. If you say you have some ability to work with French materials, you will likely be tested in the interview. So save yourself some embarrassment and be honest. It's often not something that you can really work on to much of an extent. If you have zero French, then probably your efforts are better directed elsewhere. If you have pretty good French, but it's a little rusty, it may be worth brushing up a little bit in the months before the interview if you think that will get you into the realm where your French skills will be helpful. There are other things we could talk about, but I think those are the big points. All of them, I think there's a theme. The theme is what are things that you can do that show you have the relevant skills to work as a law clerk. So if you were sort of trying to think through what would go in an application, what would help your application, think through what are the skills that are going to help me provide analysis, to a judge, thinking through some of the difficult legal questions facing the country. So that's all I'll say for now. Thanks very much.
That's great. Thank you so much, Malcolm. There are many, many questions. I'm going to mute myself and go straight to Natasha Daly for her first question, please.
Hi, thank you all so much for your time. My question is about the writing sample portion of the application. At least for the Ontario Court of Appeal, and I think this is the same across all courts, the writing sample now is at a 10-page limit. And so I was wondering if you would suggest submitting, writing a completely separate paper and submitting that 10-page paper, or would you suggest submitting an excerpt from a larger paper? And I ask this specifically because I'm interested in doing a supervised research course for credit this upcoming fall semester. And so I'm kind of thinking about the length of that paper, because that's the paper that I'd like to use for the writing sample. As well, does the subject matter about what we write about for the writing sample, as well as, sorry, I had one last question. Oh yeah, just any general tips regarding the writing sample that you would suggest.
Wonderful. I wonder if Kyle, you might take this, since you deal so closely with many, many applications.
Sure. Yeah, I think that, doing a directed research study like you've proposed, and then, if it's a 35 to 40 page paper that you end up producing, I think what you could do is try to perhaps give an abstract and then an excerpt from the paper and submit that as your writing sample. I think that seems very reasonable. I would say that would be a much better choice than, say, a factum that you might write in first year. I sometimes get questions from students to say, well, the only writing thing I really have is a factum that I wrote in first year torts. Should I submit that? I think the strategy of trying to get a substantive piece of writing done, if you weren't able to do it in the first year, in the second year, is really, really useful. In terms of the actual topic, I'm a big tent thinker. I submitted a writing sample on the rights of transgender people when they're strip searched by the police, which back in 2008 felt like a pretty, a topic that the judges I spoke to had never turned their mind to whatsoever. And it actually provided really, really rich conversations about criminal doctrine, right? And, an application of the test from the Supreme Court in Golden to a unique policy problem and a police powers problem. And so that actually was a really, really, I think, good piece for me to use, because it allowed me to differentiate myself from people who might be writing in more conventional areas. And I think it allowed for really rich discussion. So I think that your plan of getting a professor on the line to do a directed research project with, and then whittling it down to the required page limits is perfect strategy.
Well, that's great.
Okay,
Thank
perfect.
you. Let me now turn to Arthur Ferguson, who has a question that perhaps Annamaria might want to chime in on.
Sure.
Thank you everybody for doing this. My question is about the application process and interview process, and whether it's beneficial to tailor your application and I guess in the sense of the panel interview, tailor your interview to specific justices and be clear about your interests. For example, Anna, you were talking about bail and your interest in bail. So I was wondering if it's beneficial to do that in the application process generally.
I would say, as a general principle, you want to strive to be as broadly attractive as possible as a clerk. And if you're going to tailor, then only tailor to the extent that it is authentic. So don't unnecessarily restrict yourself or tell yourself that, I'm only going, or you don't want to communicate an unnecessary restriction that isn't authentic. So you don't want to say something like, I'm only interested in criminal law because, the only person that I'm interviewing with is Justice Moldaver. If you are not interested in criminal law and Justice Moldaver chose you to interview with him, it's because of something else. So play up your strengths the way that they came out in your application. And really, I think judges are very astute individuals and they can tell when you're being phony. And you want to really make sure that what you're conveying to them is an authentic and sincere love of and appreciation for law and the work of the court. And so I think you should, in terms of wanting to tailor your application, not do it. I mean, there are some people who really only want to do criminal law. And every judge will be interested in that type of person because that type of person is needed by every single judge, because so much of the work of the court is criminal law. If you're going to say that I'm only interested in tax law, you're shooting yourself in the foot. Not a lot of tax cases come in front of the Supreme Court of Canada. If you say that you are only interested in bankruptcy law as well, again, be conscious of the fact that you are putting a restriction on yourself that limits your utility to the court. Criminalists, people who have an appreciation of criminal law, are very, like, I think it's close to, I think, a third of the court's work is criminal law. So at least one of the judges, when it was 1 out of 3, one of the judges clerks would be a criminalist, someone who's interested in criminal law. With 4, I mean, sure, they'll probably choose still one person who's interested in criminal law, but again, only to the extent that you actually are authentically, and that your record displays that. If you say I'm interested in criminal law and you spent your summers working at a tax law firm and you have not taken any criminal procedure, they're going to question whether or not your statement is sincere. So try to be as sincere and authentic as you can, but I would say try to be as general, because all sorts of cases come in front of the court.
That's great. Do any of the other panelists want to add something to that answer? Thank you, Annamaria. I'll
just say quickly from experience that it's possible you'll end up clerking for someone you wouldn't have expected. And you may be pleasantly surprised, but I would keep it general. You don't know what they're looking for. You don't know who else they may have already selected by the time they're considering you, what the niche that they'll need to be filling will be. So I would echo what Annamaria said and keep it general.
So as I've been looking at the questions and trying to group them by theme, they break down into 3 kind of categories as I see it. Mechanics, the application; strategy, how should we get this golden ticket; and then court-centric questions. Does the court prioritize bilingualism, for example? Does the court like a prior clerkship, for example? I've been asked to read a couple of questions, and I'll do that, and I'll put them on the table, and perhaps anyone on the panel can just chime in with reactions or answers. First question I'm putting on the table is, I'm going to read it. I am Indigenous, and I'm wondering if there is a priority to have clerks who identify as Indigenous. First question. And then the second question I want to put on the table is, what can a 1L do this fall to optimize her ability to secure a clerkship? Jodi, Malcolm, thoughts? Kyle, Annamaria, thoughts?
I could just say quickly, I think it would be worth noting if you're Indigenous, if you have that experience, I think it would be something that the court might view as an important perspective that they might not otherwise have. So I suppose it would certainly be worth noting. Yeah.
I think so as well. I think that if you're a person of an Indigenous background, you want to say that, but you also want to go a bit beyond that and say, how do you operationalize, like, it's not just a question of your identity, it's how do you operationalize that to enhance the work of the court. So you can say, you need to highlight what perspective you are bringing. I mean, you can say that you're Indigenous, but that doesn't necessarily mean that you have a certain perspective. So talk about what perspective you're bringing, talk about what experience you have, talk about how being Indigenous has impacted your association with and encounter with the law, and how can that enrich the work of the court. So really talk about what you're bringing to the table to the court's work, beyond just merely identifying yourself as a person who is Indigenous. And the same would go for a person of color, or a person who is an immigrant, or a person who has a diverse sexual identity. Take that and talk about what that brings to the work of the court. Talk about, you know, it would be so impressive if you can take a case that has been decided by the court already and say how that case would have benefited in its analysis from your perspective and why that was missing. So saying something like that, I think, really perks up the ears of judges and be like, holy crap, I need that person. And that's what makes you more competitive.
Richard, what was the other question that you asked?
The question was about what can a 1L do this fall to prepare for applying for a clerk. Yeah. Optimize was the term the questioner asked.
Yeah, I think the number one thing if you're a first-year student is to take your academic studies seriously. It's an opportunity to sort of immerse yourself in the law, which is good, you know, I think from a long-term perspective. But grades are important. And you're, you know, maybe think about getting to know your professors and possibly thinking about what you'd like to do in future years, including, you know, thinking towards working as a research assistant, doing an independent research paper, that kind of thing. But in first year, the number one thing you should probably be doing is focusing on your substantive law courses.
Jodi, do you have any thoughts on that question? If you're going to be an oncoming 1L?
Sorry. Yeah, I would reiterate. I was going to jump in there. Yes, marks matter. So, you know, take it seriously. But also, I would say try to meet your professors, you know, for precisely the same reasons that Malcolm just said. When I am hiring RAs, I typically, I would never exclude someone that I don't know, but it's nice to see names that I know. Because they've talked to me ahead of time or because they've taken one of my classes and come to see me in office hours or participated or whatever it is. So the better you know your profs or the better they know you, the more likely they are to hire you as a research assistant, the more likely you are to develop that kind of relationship. I would say as well, you know, I can only speak, basically my knowledge right now is pretty sort of DAL-centric, but there's like a million clubs at DAL, and I you know, lots at other law schools as well, I'm sure. So it's not a bad idea to like join a student club or start to like wet your feet in community involvement and that kind of thing. That said, not to the detriment of attention to classes, which is a balance that I think students all need to strike. Yeah.
Such good advice. Thank you, everyone. Let's now go to Ali Imri, please, for a question.
Hi, everyone. So I'm a student with a disability, and my disability really restricts my capacity, so I'm only able to work part-time. And I'm really interested in applying for clerkships, but I'm worried that this limitation might be looked on unfavorably or that courts might not be willing to accommodate. So I'm wondering, from your experience, do you think courts would be open to accommodating in this way? And if so, how would you bring this up during the interview and application process?
Thank you, Ali. Thoughts from the panel? Oh, I'm sorry. Please go ahead, please, guys.
I don't think you should be discouraged by your disability from applying for the court. I think that, first of all, the court should know that it is legally required to accommodate you in your disability. I think that the workload that clerks have really vary from chamber to chamber. I wonder if there's anybody at your law school that you could talk to about how to flag that for the court. I'm sort of of two minds. I wonder whether really, I mean, for any job application, you're not required to identify a disability before applying for it, or you believe you qualify for the job. But at the same time, you do want to give the court a heads up so that they can plan and accommodate for you. It may be, this is such a lawyer's answer, but it may be worth speaking to an employment lawyer about how to best approach that kind of situation. But I don't think you should be discouraged at all. It's not a question of whether you should, it's just a question of how you need to deal with this in a way that's fair for you and fair for the court. But don't be discouraged at all. Like, I think, when I was at the court, my chambers, my judge was a little bit more chill than some other chambers. And so I think the year that I was working as a clerk was probably, in terms of my work history, one of the more relaxed years of my career. So it's definitely plausible and possible for you to have a better lifestyle as a clerk than you would as a lawyer, and as a law student as well. So I wouldn't be discouraged. It's not going to be the worst and most, difficult work year of your life. Accommodations can and should be made.
Thank you, Annamaria. Let's leave it at that and go to Raouf Asimov for a question.
Hi, thanks. My question is about the benefit of a Supreme Court clerkship after you've already completed an appellate level clerkship. I'm wondering if someone could speak to that.
Thank you.
Thanks.
Panelists.
I can speak to the benefit of a Supreme Court clerkship, but I didn't do another clerkship. So if there's anyone else that did and can speak to the experience directly, that might be better.
Sure. I clerked at the Alberta Court of Appeal the year before my Supreme Court clerkship. They're similar in some ways, but different in others. At the Supreme Court, you're more likely to be thinking through a problem, obviously, on which the court isn't bound, and often where you have different approaches at lower courts. So you're a little bit less focused on legal doctrine, although that's of course still quite important, and more focused on how the law should be developed. And of course, there are different ways of thinking through that question. I will say as well, just in terms of the intrinsic experience, Supreme Court judges are very busy. The workload is significant, and they have dozens of high complexity cases they have to think through and deliver, reasonably good answers on. And one byproduct of that I found was that Supreme Court judges are more likely to delegate significant tasks to law clerks than was the case at the Court of Appeal, just because of the workload. And so, intermediate appellate court clerkships are fantastic experiences. And of course, I'm speaking only of my own experience. But I found that it was a different experience and quite a rich experience, even having already done a Court of Appeal clerkship. So that's sort of maybe the intrinsic experience of doing it. There are also sort of questions. It's possible that it might further your career in various ways, both in academia or in practice. There's a few different things we could sort of point to there in terms of law firm recruitment of Supreme Court clerks. I think it probably does open doors. It also probably opens doors in legal academia, although maybe to not quite the same extent as was the case in the past. Now there's more emphasis placed on your graduate work. So there's sort of intrinsic benefits and I suppose instrumental benefits. I hope that helps to answer your question.
Great, that's wonderful. Our time is running out, and I want to make sure to respect the time of the panelists. If I could I just put a number of the questions that I've been given on the table? And if you want to answer one or two, a comment or one or two, that'd be helpful, but feel no pressure, okay. What about an LLM? Is that a useful credential to have when you apply? What if you have been educated in the US? Should you apply? There are sometimes US educated graduates on the court. What about if you're an international student with no connection to Canada, you just want a clerk? Is it worth applying? I think there's a rule about Canadian preference there, in fact. Okay, three more I'll put on the table. One is previous registrar experience at the Superior Court of Justice noteworthy or at all comparable to any of the skills to be used at a clerkship? And then what about applying after being admitted to the bar and working for some time? Is it still an exciting experience? And is this seen as a beneficial previous experience to have, working experience? Last question, in case you want to pull on that one instead of another one. Someone has a clerkship in Alberta after graduation, is there a lot of priority given to provinces like BC and Ontario for prior clerkships, or are clerkships from other provinces looked down upon? So choose your own adventure.
I'll go.
Oh, sorry, go ahead. Yeah.
Sorry. I only because I had an LLM before I clerked. Again, it's hard to talk about without any basis for comparison. I didn't clerk without one, but I think it might have been useful to me in getting the clerkship. I'll try to keep this short. I did a moot as a student, and Justice Binney was the judge of the final round, and I mooted in front of him, and then I went up to him at the dinner that night and said, I want to clerk, what should I do? You know, and just very bold. And he told me some of the stuff that he likes to see, you know, graduate schooling in other areas of law, in non-law prior to law school, or graduate studies in law, for example, and you know, some other stuff. So that was useful to know. I probably was a bit better at thinking through things and writing, having done my LLM before the clerkship. And I was also able to go into the interviews and saying, I'm doing an LLM and I think it's going to be in this subject, and, you know, which really demonstrated my kind of interests. I'll stop there on that for time.
I can jump in on the practice piece. So I articled at McCarthy Tetro in Toronto the year before I clerked. So I didn't spend, you know, I got my call to the bar and then immediately was off to clerk at the Supreme Court. And I would say that they're really different, and I think both are highly useful. You know, the opportunity when you're clerking to kind of pull behind the curtain and see how judges deliberate, how they work through arguments, what kinds of advocacy styles when you go to a hearing, which ones are effective, which ones are less effective, which ones seem to resonate more with judges, which ones don't. I think that was really interesting. I also think the opportunity, the work style was different, right? If you're in a big corporate commercial litigation firm, you're going to be working with a lot of different lawyers at the same time, and you're going to be managing expectations. Whereas when you're clerking at the Supreme Court, you've got a one and only, and it's your judge, and she knows exactly what she's asked you to do already. She knows exactly when your hearing dates are coming up, when your bench memo, so the document, the synthesis document that you present to your judge, she knows when those things are. So they're just a different style of work. And in my experience, I think having been articling at a big firm in Toronto, the year at the court felt like a bit of a fresh air moment for me, because it felt like I had more time to really do a deep dive into particular issues rather than feeling like there were a lot of files coming at me at the same time.
Just a quick response to the questions about US schools and international students. I think the court has a strong preference for Canadian students who study Canadian law in Canada. I think that it makes sense, because that's precisely only what we're doing. So it's much more difficult for somebody who has a law degree from elsewhere. It's difficult but not impossible for somebody who has a law degree elsewhere to be competitive as a clerkship applicant.
Final thoughts from anyone on the panel? Please, Jodi.
It's a technical point in terms of international students who have studied law in Canada. I think it's very clear on the Supreme Court of Canada website that you need to either, priority goes to permanent residents and citizens. So that's a bit of an obstacle.
That's right. That's right. Well, with that, I really want to thank the panelists. The registrants and the attendees now understand why you were my first round picks. You guys are really wonderful, so helpful. Thanks to all the attendees for your interest. I imagine the panelists are very, very busy getting ready for class and work and hearings, etc. But I also suspect that they'd be happy to hear from you by email if you have any questions, though please understand they're busy. They might not be able to respond right away. Thank you, Annamaria, Enenajor, Jodi Lazare, Malcolm Lavoie, Kyle Kirkup. Great luck in the year ahead, and good luck to all the students in the session as you continue your studies, or if you're clerking now, or if you're working now. Great luck to you. Everyone stay safe. Thanks very much, everyone.
Thank you.
Thanks.
Bye.
Good luck, everyone.
Thank you.
Bye-bye.